Hello friends, in the series on the income tax cases, today we will discuss a very important case on section 148. The name of the case is Vijay Ramanlal Sanghvi versus Assistant Commissioner of Income Tax, and this case has been reported in 457 ITR at page number 791. The matter has been decided by Gujarat High Court and the date of the judgment is 16th December 2022. As all we know that the notices under section 148 nowadays are sent to the assessees very casually because the notices are not coming under section 143 subsection 3. It is generally understood that if the assessing officer has to issue the notice under section 148, that notice should be issued by recording the satisfaction of the assessing officer that the income has escaped assessment. But we have seen that the assessing officer receives information from various sources, whether it is investigation wing, whether it is from the sale tax department or any other department, and as soon as this information is received, the assessing officer at the fag end of the limitation period of issuing the notices issues the notice without recording the satisfaction and without having reasons to believe that whether the income has escaped or not. These notices are generally sent just for making the roving inquiries, which is not allowed as per the provisions of section 148. In this case, the assessee was not assessed under section 143 subsection 3 earlier, but the notice was beyond 4 years. So the provision is that if the notice is to be issued after 4 years, then it has to be proved that the assessee has not disclosed truly and fully all the information which was necessary for assessee to give to the department. In this case, the assessee has shown all the bank accounts in the return of in his return of income, and when the assessing officer issued the notice and sent reasons to the assessee, in those reasons it was narrated by the assessing officer that the assessee has received accommodation entries in the form of 3 entries of rupees 70 lakh each, totaling rupees 2 crore 10 lakh, which is not commensurate with the income of the assessee. The main ground of the assessing officer for issuing the notice was that this amount of rupees 2 crore 10 lakh is not commensurate with the income of the assessee. The submission of the assessee was that as soon as the information has been received by the assessing officer, then the assessing officer has issued the notice on the borrowed satisfaction of the investigation wing. While the law is that the assessing officer has to apply his mind and has to record his satisfaction, it is the satisfaction of the assessing officer which is necessary for issuing the notice under section 148 and for making the assessment under section 147. But in this case, it was pleaded by the assessee that the notice is issued on the borrowed satisfaction and not on the satisfaction of the assessing officer. It was the plea of the assessee that the assessee may receive the loan which may be much higher than the income of the assessee. So that should not be interpreted that the assessee has escaped some income. The assessee also pleaded that if the assessee receives some amount, that cannot be the ground for initiating the assessment under section 147 read with section 148, and it was also the submission of the assessee. Since the assessee has repaid this loan in 2 months, if the allegation of the department is true that the assessee has taken accommodation entries, then the assessee should not have repaid this amount, because the assessee takes the accommodation entries only in those cases where generally this amount is not repaid. So it was the submission of the assessee that if the assessee has repaid the amount, then it can be safely presumed that the assessee has not taken the accommodation entries. The assessee also pleaded in the writ petition that the assessing officer has not demonstrated in the notice that how much income has escaped. Just mentioning some amounts in the notice does not mean that the assessee has escaped that much of the income. So if the notice even does not prescribe that how much income has been escaped, so in that case that notice is not as per law. When the court heard the whole matter, the court was of the opinion that this notice has been issued just for making the roving inquiries which should have been made by the assessing officer before issuing the notice. But the notice under section 148 cannot be issued just to seek the information from the assessee, and in this case the Gujarat High Court quashed the notice under section 148 on the ground that the assessing officer has issued this notice on the basis of borrowed satisfaction and not the satisfaction of the assessing officer himself. Friends, at the end of this video, once again I am repeating the name of the case. The name of the case is Vijay Ramanlal Sanghvi versus Assistant Commissioner of Income Tax, and this case has been reported in 457 ITR at page number 791. The matter has been decided by Gujarat High Court and the date of the judgment is 16th December 2022.